President Tinubu must not dishonour UN verdict on Nnamdi Kanu's case as Buhari did, IPOB leader's lawyer, Ejimakor. Barrister Aloy Ejimakor, the special counsel to the detained leader of the indigenous people of Biafra IPOB, Nnamdi Kanu, has warned President Bola Tinubu against dishonouring the United Nations Human Rights Council's opinion on Kanu's case, as former President Muhammadu Buhari did. Ejimakor said that Nigeria is duty-bound to implement the decision of the United Nations in its black letters and spirit, adding that the Nigerian government under former President Buhari was expected to do so promptly, but he dishonoured the UN. He recalled that in July 2022, the United Nations Human Rights Council, through an opinion issued by its working group, directed the then Buhari-led Nigerian government to free Kanu and accord him a pathway to compensation for his infamous extraordinary rendition from Kenya to Nigeria in June 2021. Ejimakor stated that the Council in the 17-page opinion stated, "The working group considers that, taking into account all the circumstances of the case, the appropriate remedy would be for the government of Nigeria to release Kanu immediately and accord him an enforceable right to compensation and other reparations, in accordance with international law." According to him, as a background, the Working Group of the United Nations Human Rights Council is a quasi-judicial body that has the legal mandate of the United Nations to receive and adjudicate human rights petitions against member nations of the UN. Accordingly, its decisions, diplomatically called opinions, are legally binding on all member nations of the United Nations, including Nigeria. He further noted, in addition to Nigeria being a bona fide member of the United Nations, this very UN decision on Nnamdi Kanu is primarily predicated on the International Covenant on Civil and Political Rights and the Universal Declaration of Human Rights, by which Nigeria is legally bound by virtue of its ratification by an act of the National Assembly under Section 12 of the Nigerian Constitution. To be sure, ratification is a means by which a nation makes itself subject to international laws and treaties, and by the provisions of Section 12 of the Nigerian Constitution and a plethora of decisions by the Supreme Court of Nigeria and international tribunals with jurisdiction, ratification makes every ratifying nation, including Nigeria, subject to whatever it ratified. This is non-arguable and inviolable. Ejimakor stressed that it goes without saying, therefore, that as a bona fide member of the United Nations and a treaty-bound nation, Nigeria is subject to decisions issuing from the United Nations. Thus, Nigeria is duty-bound to implement this decision in its black letters and spirit, and it was expected to do so promptly. He said that the advance copy of the opinion, which was issued on July 20, 2022, was released to him on July 23, 2022. And that the cover letter bearing the opinion indicated that the working group forwarded the opinion to the Nigerian government on July 22, 2022, yet former President Buhari failed to comply until he left office. Nonetheless, it is never too late to act, even as Nnamdi Kanu has, for 3.5 years, endured the horrendous rigours of a detention that is bereft of any legal justification. Therefore, unlike a misguided Buhari, a wiser President Tinubu can do the right thing by freeing Nnamdi Kanu without further ado. He does not need any court order to do so because the matter has transformed from the legal or judicial to the political, and as the saying goes, the buck stops at the president's table. Stay tuned for more updates.